are so many entrepreneurs out there who don't have an NDA, or they have one that's completely unenforceable, and they don't really understand when to use them, how to use them, and what makes them enforceable. I'm Karam Nahas, the 20-year battle-tested lawyer. I've drafted NDAs and I've actually argued them in court. So in this video, I'm going to show you the 5 things that every entrepreneur must know about non-disclosure agreements. That's why it's NDA 101. And I bet you didn't know at least 2 of the things that I'm going to talk about, because nobody else is teaching legal protection for entrepreneurs like this. So make sure you stay till the end. I got a free valuable gift for you, actually 2 of them. But before we jump in, I've got a free personalized legal risk analysis for your business that I created. It's completely free. Links in the description below. I'll mention it again in the end, but let's go. Let's get right into the video. Here's a quick foundation before we get into the 5 things. An NDA is a non-disclosure agreement. It's a contract that creates a legal obligation on the person who's receiving your confidential information, and they're required not to disclose it and not to use it without your permission. That's the core. That's what it does. But here's what most entrepreneurs miss or they don't understand. An NDA is not just a standalone document. You sign it before a big pitch meeting. It's language that should be embedded into every significant agreement you have. Your contractor agreement should have it. Your partnership agreements should have it. Your vendor agreements, your client agreements. And this provision and language should differ depending on the scenario. Think of it less as a separate document and more of a provision that belongs in literally every contract where confidential information is involved. And in business, that's like most of them. So now let's jump into the 5 things. Number 1, most entrepreneurs think NDAs are only for the big deals or investor conversations, and that's completely wrong. There are 3 situations where every entrepreneur needs an NDA, and missing any one of them is serious exposure and dangerous. Situation number 1, contractors and anyone else inside your business that has access to this information. This is the most overlooked and the most dangerous situation. Anyone who works inside your business, developers, VAs, designers, systems people, social media managers, you name it, they see everything. Your client list, your processes, your pricing, your proprietary systems, your methodologies. Before they see a single thing, they need to sign an NDA. Not after the project starts, not after the relationship develops, but before. On day 1, before they see anything important. The second situation you need is when you're pitching your idea or raising money. This is really important. Before you pitch your concept to a potential partner or investor, before you share your business model with a potential investor or the rest of the world, before you show your system to anyone considering a collaboration, a one-way NDA is necessary. You sign it before a single word of your idea leaves your mouth. Now, most entrepreneurs skip this because they don't want to seem distrustful, or they think they're not enforceable, and then they wonder why their idea is being built by somebody else 6 months later, and they've got absolutely no legal recourse. So situation number 3 is with your business partner in conversations. When both sides are sharing confidential information, strategies, client data, financial information, proprietary systems, both sides need protection. That's a mutual NDA. When both parties are sharing pretty much equally, both parties are bound, they sign before the conversation begins. These are 3 situations where you need 3 types of NDAs, and in every one of them, the NDA is only as good as what's inside of it. It's language. This brings us to the number 2 thing you got to really understand when it comes to NDA. You got to define confidential information specifically and trace it to yourself. This is really important. Trace it to yourself. This is the most important lesson, probably the entire video. I should have left at number 5 so you watch the whole video, and the one that entrepreneurs get wrong consistently and what ends up in court the most. Here's the mistake. Your NDA says all information shared between the parties is confidential and may not be disclosed. Courts reject this. It's too broad every single time, because if everything's confidential, then nothing's really confidential. So that definition is legally meaningless. It's not good. Courts need specificity. They need to know exactly what categories of information are protected, what type, what format, what scope, what it is, and it has to be traced to you. Now, there has to be a real definition of confidential information, and this is what it looks like. Client lists and confidential information, pricing and financial data, proprietary system and processes. That's how you define it. Methodologies and frameworks, trade secrets and know-how, marketing strategies, and campaign data. Any information marked confidential or disclosed in circumstances indicating its confidential nature, named, specific, exhaustive. That's the standard you got to use. But here's the second part of the lesson, and this is what's really important, the one that most lawyers miss entirely, and the one that has cost entrepreneurs everything in litigation. I've litigated a couple of these cases. You have to trace confidential information to yourself so the other party doesn't claim it's theirs. You get it? Let me give you the exact scenario I've seen played out in litigation. This happens a lot in sales when you have a book of business. So you build a book of business, real relationships, real clients, real contacts you've developed over years. Now you go into business with a company or a partner, you're bringing those relationships with you. And you start doing sales for them. Now 2 years later you leave or they push you out, whatever, there's a dispute. And now you're arguing, now you're in court. And now they're claiming that your clients are their confidential information. And I've seen this play out over and over. They're claiming that your clients are their customer relationships, that your data is their protected data, and you're in court fighting over whose clients are whose. And the judge trying to reconstruct who had what relationship before the deal started. They don't care. There's no clear documentation. There's no dated record. There's no evidence of what you brought in versus what you built together. You didn't give a list attached to an agreement of what your existing book looked like. That fight's expensive. That fight is unpredictable, and that fight's almost entirely preventable for sure. It's going to cost so much in litigation, and a judge doesn't care. They're not going to reconstruct this. They're going to base it on what you guys come up with, and it's going to get settled, and you're going to end up giving up some of your clients. That's just how it works because most cases never go to trial. And this is a complete legal disaster that could have been completely avoided. Here's the fix. Before you sign any NDA, before you enter any partnership or business relationship where you're bringing in your own clients, contacts, or relationships, I want you to document what you brought in right away. Create a list, date it, attach it to the agreement as an exhibit. It's Exhibit A. That's your book of business as of the date the relationship started. If it's unclear to you, put the name on there. Signed by both parties, clearly establishing what was yours before the relationship began and what was developed during it. Get it? This is priceless information. Hit the like button if you like what you hear. Subscribe to the channel if you want to hear more tips like this. So their confidential information is what came after. So everything on that list that you provide as part of the agreement, dated before the relationship started, is yours. So without that documentation, a judge has no basis to separate what you brought in from what they claim is theirs. That's going to require a lot of witness testimony, a lot of discovery, and a lot of expensive litigation. That ambiguity becomes a weapon to be used against you. And there's one more thing on defining confidential information you really got to understand. If you do business across multiple states, draft your definition to survive the most restrictive jurisdiction you operate in. California has some of the toughest confidentiality standards in the country. You kind of have to know the law that differs in every state. If your NDA survives California scrutiny, it will survive almost anywhere else in America. Here's the number 3 thing you got to really understand, and that's liquidated damages. They give your NDA real teeth. So here's the problem most entrepreneurs don't think about until they're in court and it's too late. You find out someone breached your NDA. They used your confidential information. They disclosed your trade secrets. It's a huge problem for you and you've been damaged. The breach is clear. You have evidence, but now you have to prove what that cost you. You got to prove your damages with legal certainty. That's the standard. Certainty. Loss of revenue is speculative. Damage to your business is speculative. Lost opportunities are speculative. Reputational harm is speculative. You have to define things with certainty. I told you this before. Speculative damages don't win cases, and without provable damages, even a clear breach of your NDA gets you almost nothing. You have to understand this. So this is where liquidated damages change everything. A liquidated damages clause means you and the other party agree up front in the NDA itself on a specific dollar amount owed in the event of a breach. It's predefined, it's pre-agreed, it's certain. Now when you go to court, you don't have to prove what that breach actually costs you. You point to the clause, you tell the judge that there's a specific number to enforce that the parties agreed to. We all agreed that it was reasonable. It's clear legal obligation that the other side agreed to and signed. And the judge is going to love it because you both agreed to it. It's simple and they can go to lunch. But for a liquidated damages clause to be enforceable, you need 2 things. Actual damages were genuinely difficult to calculate at the time the agreement was signed. Damage to reputation is a great one. Number 2, the amount agreed to is a reasonable forecast of what a breach would actually cost. It can't be a penalty designed to punish. It has to be a forecast, a reasonable estimate of real harm. That's what the restatement of contracts say. Every NDA you sign from this moment forward needs a liquidated damage clause. It's the difference between a court that can enforce your agreement in a meaningful way and a court that rules in your favor but leaves you with nothing and tells you, listen, there's no liquidated damage provision in this contract. You got to understand the way to get relief in court. If this is hitting home, hit subscribe. I break down legal strategies like this every week so entrepreneurs can stay stop learning these lessons the hard way and avoid legal mistakes. Here's the number 4 thing you got to really understand about NDAs. Irreparable harm and injunctive relief, and getting access to the right court is tremendously important. This is the provision most entrepreneurs never think about, never heard of, and it's the one that can save your business when a breach happens. Trust me, when somebody violates your NDA, your instinct is to sue them for money damages. Let's go into civil court. That's what most business owners think. Prove the breach, collect what they owe you, and move on. But that's not the best court to be in, because the problem is civil courts are for money damages, and it's slow. We're talking months before you get in front of a judge, sometimes years before trial. Meanwhile, your confidential information is being used against you right now, and you've got no recourse. Your client list is being worked. Your proprietary system is being replicated. Your trade secrets are being shared with competitors, and all you're doing is in court asking for a piece of paper that they owe you money, and then you're going to have to go collect it. And by the time you get this money judgment, the damage is done. Your clients are gone. Your market position is compromised. You may not even be able to collect on that judgment. Your business is permanently harmed. That's why you don't want civil court for money damages. You want to get to equity court, chancery court, federal court. You want to get there and get immediate relief. The tool that gets you there is an injunction, or it's to show cause. An injunction is a court order that stops the other party from doing something right now, not after a trial, not after discovery, not after the evidence is gone, right now within days of filing. A judge can order the other side to immediately stop using your confidential information. They can order them to stop contacting your clients, stop operating the competing business they built on your trade secrets. They can order an accounting immediately before the full case plays out. These judges have tremendous power, and it's discretionary. They can give you the relief to order specific performance, not just money damages. But here's what most entrepreneurs and also lawyers miss. To get an injunction quickly, your NDA needs specific languages establishing that a breach causes irreparable harm. Irreparable harm means the damage cannot be adequately compensated by money alone. This is extremely important. The harm is so unique, so hard to quantify, that only injunction can provide real relief. So if your NDA already contains language stating that breach constitutes irreparable harm and that the non-breaching party is entitled to seek injunctive relief without posting a bond, you've dramatically lowered the barrier to getting emergency relief. Now, without that language, you're fighting for a right to get an injunction on top of fighting the underlying breach. It's nearly almost impossible. 2 battles at once. It's so expensive, time consuming. It can be in 2 different courts, often too late. So with that language, you go directly to a court of equity or federal court. You file for an emergency injunctive relief. You're in front of a judge within days. You do the order to show cause. You show irreparable harm. That's the provision that stops the bleeding while the case is decided. That's what gives your NDA real power, gets the judge on your side, and allows the judge to be creative with the mechanisms that they can use to give you relief other than money damages, because at the end of the day, a judgment, a piece of paper is not going to really help your business. So here's the number 5 thing you got to understand about NDAs. Attorney fees, enforcement costs, and the non-solicitation provisions, they should be included, and a lot of lawyers forget them. Here's the last lesson, the one that most lawyers miss. Let me start with attorney fees. Most NDAs can be silent on who pays to enforce them, which means if someone breaches your NDA, you pay your own legal fees to fight them, and that's wrong. Even if you win, even if the breach is clear and obvious, it's not your fault, litigation is expensive. A breach of a confidentiality case can cost tens of thousands of dollars in legal fees before you even see a courtroom. Trust me, and if you win, you collect the liquidated damages, but you spent more than you've recovered fighting for them. So an attorney fees provision changes that equation entirely. Your NDA should provide that in the event of a breach, the breaching party is responsible for all legal fees and all costs incurred by the non-breaching party. Pre-litigation fees included, litigation fees, and critically, post-judgment collection fees. This is leverage. This is teeth. This is how you get things settled, because winning a judgment is not the same as collecting a judgment. If you win in court and they don't pay, you have to go back to court to collect. You got to start an entirely new process. More legal fees, more time, more cost, probably a new lawyer. An attorney fees provision that covers pre-litigation, litigation, and post-judgment collection fees makes breach genuinely expensive for the other side and makes enforcement economically viable for you and allows you to get lawyers who are willing to take the case. So now let's talk about the 2 non-solicitation provisions entrepreneurs forget about entirely. You got customer non-solicitation. After the relationship relationship ends, they can't contact your clients. And I've litigated these cases. This is the one most entrepreneurs include when they include anything, and a lot of times they don't. But even this one is often too vague and problematic. It needs to specify which clients. All clients they had contact with during the relationship, for how long, and what solicitation actually means. That's really important. Define it specifically. Then you have employee non-solicitation. This is the one almost nobody includes, and it's the one that destroys businesses when a key contractor or partner leaves. After the relationship ends, they can't recruit your team. They can't contact your employees. They can't offer your contractors better rates and try to take them from you. They can't reach out to anyone they met while working inside your business and pull them away. They can't initiate the contact. And trust me, we litigate about this all the time. So without this provision, a departing contractor can walk out your door and immediately start recruiting your entire team to start their new venture and compete with you. That's completely legal. No agreement in place, nothing you can do about it. There's no legal recourse. Customer non-solicitation protects your clients. Employee non-solicitation protects your team. Both need to be in your NDA. Both need specific definitions, and both need enforcement provisions with the same teeth as the confidentiality provisions. They're there to get you settlements and what you want, and both need to work together with everything we've covered here today. Specific definitions, liquidated damages, irreparable harm language, attorney fees, all of this comes together to create the ultimate NDA that actually protects your business when you need it most. And I litigate, so I understand this, and I promise you a free gift. It's the ultimate NDA checklist, all 5 lessons in a checklist that you can use right now to audit every NDA in your business. Make sure yours is legally bulletproof, like the ones that I sell. So this checklist is completely free. Links in the description below. Grab it now. And of course, don't forget to get your free personalized legal risk analysis built by me, the 20-year battle-tested lawyer. It's specific to your business. It literally takes you 5 minutes. It's a $7,500 value if I did it in person. The link is in the description below. Find out exactly where your business stands, who your business threats are, and how to fix them. I'm Karam Nahas, the battle-tested lawyer. Remember, defense wins championships, and your job is to stay legally bulletproof.